23andMe Bankruptcy. Should you worry about your DNA data? The bankruptcy of 23andMe raises alarming data privacy issues. Should we be worried? In the realm of legal practice, managing business transactions is a routine task. The process of transferring personal data during acquisitions, sales, mergers, or bankruptcy proceedings has become second nature for professionals in this field. We conduct comprehensive due diligence for these transactions, ensuring that privacy policies permit the transfer of personal data, and we negotiate essential contracts with existing partners and data recipients. These steps are vital as they can significantly enhance the valuation of a business. In light of this, the recent bankruptcy filing by 23andMe has ignited a heated discussion. Regulators and advocates for consumer privacy are urging individuals to erase the data that 23andMe possesses about them. They are also pushing for more robust privacy legislation. A report from the court-appointed Consumer Privacy Ombudsman, CPO, issued on June 11 has raised red flags regarding the potential sale of information in connection with the bankruptcy. For further insights, check out our article, 23andMe Bankruptcy, the Privacy Ombudsman's Report. The concerns being voiced largely stem from the uncertainty surrounding who might acquire 23andMe, their intentions for utilizing genetic and lineage data, and the perceived lack of adequate legal protections for consumers. However, this reaction appears to be somewhat exaggerated. Not every business transaction involving personal data triggers such alarms, and even the security breach that occurred at 23andMe in 2023 did not elicit this level of concern. So, why does a bankruptcy sale provoke such anxiety? Data breaches, especially those involving sensitive information, present serious risks. Malicious actors often escape accountability, making it easier for stolen data to be disseminated among other harmful entities. For these individuals, legal frameworks are irrelevant. The real value lies in accessing and exploiting a wealth of personal data for their own benefit. In contrast, any potential buyer of 23andMe would be subjected to rigorous scrutiny and legal responsibilities, including adherence to privacy policies, implementation of strong security measures, and compliance with existing laws governing such transactions. Any acquirer would be required to honor the commitments that 23andMe made to its customers during the onboarding process. Thus, the call for customers to delete their data from 23andMe would not only be unnecessary but could also hinder the sale of the business to a legitimate buyer. Critics argue that the fragmented nature of state privacy laws, along with specialized health and genetic data regulations and HIPAA, creates numerous gaps in consumer protection. However, this perspective misses the mark. In the context of transferring personal data between businesses, existing legal obligations, enforceable at federal, state, and local levels under consumer protection laws such as unfair, deceptive, or abusive practices, UDAP, statutes, provide a solid foundation for safeguarding data during business transactions. When these legal principles are followed and enforced, they ensure that such transactions are not inherently harmful to consumers. Personal data is often viewed as the cornerstone of business value in transactions. However, the true worth of personal data is directly linked to the strength of the target company's privacy and security practices. Companies that emphasize transparency, obtain consent, and invest in data protection are inherently more valuable. Conversely, inadequate data protection practices can diminish business value. Thorough due diligence during negotiations evaluates these practices and informs the terms of business transfer agreements, which typically include representations and warranties regarding compliance with applicable laws. Both parties, the target and the acquirer, commit to upholding these legal standards. To facilitate the transfer of personal data as part of a transaction, this transfer must be explicitly stated in the privacy policy at the time of data collection. If such disclosure is absent, notice and consent are required, even if the privacy policy allows for updates at any time. Making retroactive changes to processing practices without notice and consent violates UDAP statutes. Tools like the Wayback Machine help ensure accountability by preserving snapshots of privacy policies. Moreover, any acquirer of 23andMe must comply with the existing privacy policy and is prohibited from significantly altering how the data is used without notice and consent. Any new purposes, security measures, or disclosure practices would require explicit approval from consumers. Given that 23andMe is known for its stringent privacy protections, any acquirer must uphold these standards. Additionally, the acquirer is bound by the enhanced security measures resulting from the $30 million settlement following the 2023 breach, which impacted approximately 14,000 accounts due to credential stuffing. If regulators and consumer privacy advocates have confidence in 23andMe's current practices, there is little reason to doubt the practices of the acquirer, as long as they adhere to the same obligations. For example, if 23andMe does not share genetic data for hiring, insurance, or other purposes without consent, the acquirer cannot do so either. Even sharing data with law enforcement outside of valid legal requests would necessitate consent. Consumer rights, including the ability to delete their data, must also be preserved. The Federal Trade Commission, FTC, and state attorneys general consistently enforce UDAP statutes regarding data transfers in business transactions. While stronger privacy laws could be advantageous, a deeper understanding and enforcement of existing legal obligations are crucial. These measures help build trust among regulators, businesses, and consumers while maintaining the value of companies undergoing acquisitions. And Wojcicki's $305 million 23andMe nonprofit comeback, Silicon Valley redemption. What if your genetic information, once a private matter, became the center of a Silicon Valley soap opera? And Wojcicki is rewriting the script on DNA testing, and controversy is swirling. Her dramatic re-entry into 23andMe's leadership has reignited one of tech's most meteoric, yet tumultuous, company arcs, inviting both admiration and skepticism. But here's where it gets controversial. Has her comeback truly been about public good, or is it just an ambitious move to restore her own legacy? This week, Wojcicki astonished the tech world by buying back 23andMe, the now bankrupt genetic data company she co-founded, for a hefty $305 million. In a surprising turn, she outmaneuvered pharmaceutical giant Regeneron, which thought it had secured the deal, only for Wojcicki to successfully argue the earlier auction was unfair. This audacious bid has ensured she maintains the reins of a venture closely tied to her personal narrative. As a nod to repositioning, she's transitioned the company under the non-profit TTAM Research Institute, declaring her resolve to use genetic research to improve lives, a mission she shared with followers on X. And this is the part most people miss. Transforming a for-profit company into a non-profit doesn't necessarily mean it's suddenly charitable or humble. Take OpenAI as an example, the non-profit turned AI juggernaut, now valued at hundreds of billions. Is 23andMe's pivot a genuine bid to serve society, or a strategic play in the high-stakes world of tech branding? Looking back, 23andMe wasn't just built in a lab, it became a cultural movement, making its debut at glamorous speed parties where celebrities eagerly submitted saliva samples for DNA analysis. Imagine the buzz as guests mingled at events like Davos or New York Fashion Week, hoping to uncover secrets hidden in their genomes. These moments encapsulated the era's techno-optimism, in which sharing even your most private data was sold as exciting and consequence-free. Stories of discovering long-lost siblings, and, sometimes, unexpectedly meeting a new parent, became media sensations. But not all surprises were happy, raising deeper questions about privacy and the emotional weight of genetic knowledge. Let's not gloss over Wojcicki's Silicon Valley pedigree. After marrying Google co-founder Sergey Brin, who also invested generously in 23andMe, and basking in the company of tech royalty and world leaders, her profile soared. Time magazine named the home DNA kit the invention of the year in 2008, while her family's influence was cemented by a commemorative Barbie collection honoring her and her sister's achievements. But bold moves often invite backlash. Co-founder disputes led to high-profile exits, raising eyebrows about Wojcicki's management style. As years passed, thorny questions about business sustainability grew louder. Customers were intrigued by the initial DNA insights, but what would keep them engaged or paying long-term? Here's where things got even more complicated. In 2013, U.S. regulators stepped in, halting 23andMe's genetic tests over concerns about their accuracy and usefulness, shaking confidence in the company and its leadership. Although the FDA eventually permitted limited disease tests, critics pointed out that knowing one's risk for disorders like Parkinson's offered little comfort without effective treatments. Going public through a high-profile SPAC deal, 23andMe achieved a staggering $6 billion valuation before its shares tumbled and new scandals surfaced. A massive data breach in 2023 exposed the information of customers worldwide, over 155,000 from the UK alone, leading to a significant fine from Britain's data authority and a major US class action settlement. Public anxiety soared. Could Silicon Valley giants truly be trusted with the world's most intimate data? By September 2024, Wojcicki stood isolated as the entire board resigned, openly doubting her vision. The following March, 23andMe filed for bankruptcy protection, and Wojcicki herself stepped down as CEO. The shockwaves were immediate. Customers worried their DNA data might be auctioned off, prompting nearly 2 million people to demand their records be erased. Now, as Wojcicki steps back into leadership, her primary challenge is clear: restoring trust. In the aftermath of these scandals, can she convince users that their most sensitive information won't be sold or mishandled? Her redemption arc, and, by extension, 23andMe's, may hold lessons for the whole tech sector about privacy, accountability, and the real value of innovation. But here's a provocative thought: could 23andMe's journey be a harbinger for how Silicon Valley rebuilds public confidence, or does it signal a deeper problem with tech's hunger for our personal data? Is the non-profit pivot a bold reset or, as some critics suspect, just a clever rebranding to avoid financial collapse? What do you think? Are you reassured by Wojcicki's return and the non-profit status, or do you remain wary of big tech's promises around privacy? Does the public really benefit from democratized DNA analysis, or are the risks too great? Share your thoughts, opinions, or fiery disagreements in the comments below. The conversation about who truly owns your genetic data is just beginning. How 23andMe was saved. Inside the $305 million bankruptcy sale to end Wojcicki's nonprofit. Litigators of the week, navigating the $305 million bankruptcy sale of 23andMe. In a remarkable turn of events, the legal teams behind the $305 million bankruptcy sale of the genetic testing firm 23andMe have successfully guided the process to completion. This sale is particularly noteworthy as it transitions the company to a newly established non-profit organization, spearheaded by none other than Wojcicki, one of the original co-founders of 23andMe. Leading the charge for 23andMe was Christopher Hopkins from the prestigious law firm Paul, Weiss, Rifkind, Wharton and Garrison. His team played a crucial role in managing the company's voluntary Chapter 11 bankruptcy proceedings, which were initiated back in March. Meanwhile, Joseph Larkin from Skadden, ARP's, Slate, Moore and Flom represented Wojcicki and the TTAM Research Institute. They were instrumental in reopening the bidding process last month, ultimately exceeding the initial offer of $256 million made by Regeneron Pharmaceuticals. This situation raises intriguing questions about the future of genetic testing and the implications of such a significant sale. What does it mean for consumers and the industry at large? This premium content is exclusively available to subscribers. If you are already a subscriber, please sign in to access your subscription. Not quite ready to subscribe? Join the law.com community today and enjoy access to one free article from across the law.com network every 30 days. Note: some premium content may be excluded from this offer. Join the law.com community. For inquiries regarding group subscriptions, please reach out to an account specialist at email protected or call 1-855-808-4530, Americas, or 44 0800 090 8386009, UK and Europe. We value your feedback. Feel free to share your thoughts through our feedback form.